going here. Good evening and welcome everybody to the February 18th, 2021 Historic Resources Commission meeting. My name is Luke Mortensen and I will be facilitating the Zoom video portion of tonight's meeting. Participating live with me from the City Commission room is Lynn Braddock-Zollner, Historic Resources Administrator. We will work alongside the chair, who is on remote video, to facilitate the meeting proceedings. Currently, everybody should be muted so we can talk through the general ground rules for tonight's meeting. The meeting is being recorded and broadcast live on the city's YouTube channel and public access cable channel 25. During the meeting, please mute yourself by clicking on the microphone icon found on the lower left-hand corner of the Zoom menu next to the video icon. When you are muted, a red line will appear over the icon. This will make it easier for everyone to hear the meeting. Just remember to unmute if and when you want to speak. In the menu, you can also turn your camera on or off by clicking the video icon located next to the microphone icon. For the purposes of this meeting, please keep your video on for the duration. If you are participating by phone, you can enter *6 to mute and unmute your phone. Somewhere on your Zoom screen, you will also see a choice to toggle between speaker and gallery view. Speaker view shows the active speaker. Gallery view tiles all the meeting participants. Commissioners, you must state your name and title each time you speak. Members of city staff must also state their name and title each time they speak. I would also ask the applicants, members of the public, identify themselves each time before they speak to ensure that everyone is able to follow along. When public comment is sought on an item, individuals participating via Zoom should use the raise your hand feature. Windows and Mac users can access this feature through the participants button at the bottom of their screen. Android and iPhone users can access this feature through the More button located at the bottom right corner of their screen. For those calling in by phone, you may dial *9. Individuals will be called upon by name in the order they appear on the meeting host's screen. When you are called on, please unmute your listening device and state your name before speaking. The chair will then call for in-person public comment for those who are physically present. Staff will direct those to the podium to speak while following social distancing and safety protocols. The regular 3-minute time limit will still apply. All motions will need to be stated clearly. After a motion is made and seconded, the chair will then call on each commissioner individually to provide their vote. Staff will then need to announce whether the motion carried and the count of the vote. I'd like to remind everyone once more, please remember to mute yourself when you're not speaking. At this point, I will turn it back over to Chair Meyer.
Good evening. Go ahead and call to order the February 18th Historic Resources Commission meeting. I'm going to go ahead and do a roll call of commissioners tonight. Commissioner Buchanan-Young.
Here, sorry.
No problem. Commissioner Foster, I don't think is here. Okay. Commissioner Irby. Well, I know she's here.
Lynn Braddock-Zollner, Historic Resources Administrator. She may not, she was joining when you called for her, so you may need to call.
Okay, Commissioner Irby.
Hi, you're sorry.
No problem.
Activity issue.
Commissioner Fry.
Present.
Commissioner Holder.
Present.
Commissioner Hawley.
Present.
Okay. So we're all here except Commissioner Foster. All right, we will begin with communications this evening. And I believe that we have received one communication. Lynn, have there been communications from any other commissions, the State Historic Preservation Officer or the general public?
Lynn Braddock-Zollner, Historic Resources Administrator. We have no communications other than the one that was included in your packet.
This is Chair Meyer. Lynn, is this something that the individual was wanting the Historic Resources Commission to weigh in on, or just asking you personally?
Lynn Braddock Zollner, Historic Resources Administrator. I think it would be appropriate for the Historic Resources Commission to receive the letter and refer it to your new Monument Committee, your subcommittee, and they can look at that and maybe get back in touch with you, and then you can respond to the person that sent the letter.
All right, this is Chair Meyer. That sounds like an excellent idea. I don't know that that necessarily requires a motion, does it?
Lynn Braddock Zollner, Historic Resources Administrator, you could go ahead and move to send it to the Monument Committee.
All right, this is Chair Meyer. I will go ahead and move that the communication regarding the plaque be sent to the Monument Committee. Is there a second?
This is Commissioner Fry. I second that motion.
Okay. Go ahead and take a vote. Commissioner Buchanan Young,
Aye.
Commissioner Irby,
Aye.
Commissioner Fry,
Yes.
Commissioner Holder,
Aye.
Commissioner Hawley,
Aye.
and Commissioner Meyer is an aye. So that motion carries 6-0. All right, is there any disclosure of ex parte communications this evening by commissioners? All right, I don't see any. Are there any declaration of abstentions from specific agenda items by commissioners? Okay, I don't see any of those either. Are there any committee reports this evening?
Lynn Braddock Zollner, Historic Resources Administrator. You have no committee reports this evening.
Right, this is Chair Meyer, and we will then move on to the consent agenda. We have administrative approvals, and there were several design review applications that have been administratively reviewed and approved by staff. Lynn, is there any public comment on this item?
Do we have any public comment?
Luke Mortensen, Planning and Development Services. We do not have any Zoom public comment. And
All right, this is Chair Meyer. Is there any commission discussion about any of the administrative or any of the design review applications? Or a motion to confirm the design review applications?
This is Commissioner Fry. I move to approve the consent agenda.
All right, this is Chair Meyer. Is there a second?
This is Commissioner Hawley, second.
All right, since there's a motion and a second, we'll go ahead and do a roll call. Commissioner Buchanan Young?
Aye.
Commissioner Irby?
Aye.
Commissioner Fry?
Yes.
Commissioner Holder?
Aye.
Commissioner Hawley?
Aye.
And Commissioner Meyer is an aye. So that motion carries 6-0. All right, we will then move on to general.
No, she's muted.
Commissioner Meyer, you're on mute.
That's how my kids like it. Thank you. Is there, what did you last hear?
Lynn Braddock Zollner, Historic Resources Administrator. It would be appropriate for you to go ahead and start at the beginning of your accepting public comment.
Oh, okay. All right, then is there any general public comment this evening?
Luke Mortensen, Planning and Development Services. There are no Zoom public comments and there are no in-person public comments either.
All right, this is Chair Meyer. Since there is no general public comment this evening, then we will move on to the public hearing items. Lynn, I realize that Historic Resources Commission training is the first item. I don't know how long that's going to take. Do you think that's going to take a while? I guess I was thinking about taking it out of order and addressing the number 2 on the agenda regarding the sign.
Lynn Braddock Zollner, Historic Resources Administrator. I believe the person doing your training has another engagement, so I think that's why we put him on first.
All righty, then we will take up the training portion of the evening.
Good evening, Commissioners. My name is Randy Larkin. I'm a Deputy City Attorney. And tonight we're going to give a presentation or a little training on the Kansas Open Meetings Act and conflict of interest laws in the state. Luke, I think, is going to help me with a PowerPoint presentation. So Luke, you can call that up whenever you want. Even for lawyer stuff, this stuff is kind of dry. So if you have any questions as we go through and made it a little more interactive, that would be great. So if you have any questions, just feel free to interrupt me and I'll answer them to the best of my ability. And that being said, even though this is kind of dry stuff, it is very important basically to keep yourselves out of trouble, keep Lynn out of trouble, keep the city out of trouble. And hopefully we can all do the business of the city and stay out of trouble. All right, we'll go on with the Kansas Open Meetings Act. Kansas Open Meetings Act was enacted in 1972 as part of a wave of reform in government at the time. It was goal was to move local government out of smoky back rooms into the public, so the public would have access and that the business of the public would be done in front of the public. It has been described as the cornerstone of public access to local and state government. And for that reason, it is a policy of the state that the representative government is dependent on an informed electorate. And this is crucial to that goal. And for that reason, it is also an express policy of the state that is a violation of the Open Meetings Act to move a meeting or to try to subvert the intent of the Open Meetings Act and work around the public. The courts construe the Open Meetings Act liberally and its exceptions narrowly. So what that means is basically if it's a close call, it's probably going to go against the city. So we try and be very conservative when dealing with the provisions of the Open Meetings Act. All right, Luke, the next one. Basically, there are two things that are required before the Open Meetings Act applies. The body must be a covered entity and there must be a meeting. Next, Luke. Bodies subject to the Act are all state agencies and political and taxing subdivisions, including the city of Lawrence, and any subdivision of any body of the city of Lawrence, including the Historic Resources Commission. So that pretty much goes without saying that the Historic Resources Commission is a covered entity under the Open Meetings Act. All right, next, Luke. Now, the most important, this is where most of the gel or the importance of this act is the meeting. A meeting occurs when there is any gathering or assembly in person through the use of a telephone or other medium for interactive communications by a majority of the membership of the body for the purpose of discussing the business affairs of the body. So there are three things that have to happen before there's a meeting. There has to be some type of gathering or assembly, either in person or electronically, by a majority of the membership of the body, and the discussion has to be the business of the body. All right, next, Luke. And act applies when there's interactive communications. It happens when they are in physical presence of one another. Could be a telephone call, including conference calls. It could be video conferencing. It could be a Zoom session. All those count as a meeting. If you send an electronic email to everybody, that could very well be a meeting. So be very careful, especially when you have, there's, emails going around. Try not to hit reply all. Some people have gotten into trouble under the Open Meetings Act because they hit reply all, and all of a sudden there's interaction. There's a majority of the members of the body, and then you have the reply all where it's discussing the entire the business of the body. So anyway, that's interactive communications. Next, Luke. A majority of the membership, there's 7 members of the Historic Resources Commission, so a majority is 4. So there has to be any communication of the business of the body involving 4 members might trigger Open Meetings Act. All right, next, Luke. And then to discuss the business of the body. Now, it doesn't take binding action, doesn't have to be a vote, doesn't have to even be a decision to trigger discussing the business of the body. Basically, all you have to do is be discussing something that is the business of the body, something that's going to come before you, something that has come before you in the past, but it's the business of the Historic Resources Commission. Now, social gatherings are not subject if you do not discuss the business of the body. So you guys can have a get together at some point in time once the pandemic ends or something, or you can do it by Zoom to say hi and just talk, have social gatherings where you're not involved in discussing the business of the body. That's okay. You could all attend the same conference as long as there's no interactive communication among more than 4 of you, and that's all fine as well. All right, Luke, next. Now, one thing to be aware of is electronic communications. Interactive discussions may raise COMA issues. A single email sent to other commissioners probably would not be, but like I was talking about before, please refrain from hitting reply all. All right, next, Luke. Also, social media. Simultaneous Facebook posts concerning the business of the body, if it goes to enough people, could be a problem. There was a recent example that came out of down south somewhere in the state where a majority of the city members were talking about a hospital appointment on social media, and they just all happened to do it kind of at the same time. This was after they had appointed a member to, I think, to the hospital board. It was a municipal hospital, and they had to enter into a consent order with the Kansas Attorney General, and it was a big deal. Anyway, just be wary when you use electronic communications, when you use social media, when talking about matters that are before this board. Next, Luke. I think this is all covered. Facebook, all those things. Okay, next, Luke. Again, emails has been covered. On to the next one, Luke, thanks. One thing to be aware of is a serial meeting. Basically, what that is a serial meeting is a violation of the Open Meetings Act. And what it tries to avoid is a situation where Commissioner 1 says what they're going to do to Commissioner 2, and Commissioner 2 talks to Commissioner 3, et cetera, and then discuss the business of the body through a series of communications involving a majority of the membership of the bodies. This is a violation just as much as if you were all together or if you had a video conference or something like that. So try not to have a situation where one commissioner talks to another, that commissioner tells another one what's going to happen. And then anyway, a serial meeting like this is a violation of the Open Meetings Act. Next, Luke. Again, all right, here's what is the key to COMA. If there is a meeting, if there's an interactive communication by 4 members of your body, and you discuss the business of the body. It could be anything that's appearing before you, that has appeared before you, will appear before you. Those are the types of things. Now, it does not apply to just procedural matters like the time of the meeting or those types of matters, but it has to be the business of the body. Okay, next, Luke. All right, in addition to that, it has to be a COMA also requires several other things that probably don't apply to you, but it's good that you know. This more applies to the city staff. If there's a meeting, proper notice and public notice have to be given. Meetings have to be held in a place that's accessible to the general public. which is why we do it by Zoom, and we allow public to watch if we can. We record these so that they can see it. We have people at City Hall, just in case they don't have communications or ability to access these meetings online or by telephone, where they can come and watch these meetings. It has to be accessible to the general public. On to the next loop. Notice has to be, as does not require notice be given within a particular time frame. It just has to be reasonable enough that people have an opportunity to appear and watch or observe the meeting if they want to. Next. Now, the Open Meetings Act does not require that agendas be made, but if one is made, it must be made available to those who request them. It should be followed. Those are the plans for discussion, but agendas can be amended as necessary and within the discretion of the body. Just can't use that, amending the agenda, to subvert the purposes of the Open Meetings Act to try to set it for another time when someone won't be there perhaps, or something of that nature. Next, Luke. All right, now, before we get to the conflict of interest laws, I would want you to know that if there is a violation of the Open Meetings Act, any person who's aggrieved by it can bring an action. The district attorney can bring an action. The attorney general can bring an action. The remedies include injunction, mandamus, civil penalties, payments of costs, other appropriate orders. If an action is brought to enforce the Open Meetings Act, I'll give you this. It is thought of as important enough where they will set things aside. The court will have to set things aside on its schedule to hear this before it hears other things. That's how important it is to the state. Penalties could be a civil penalty of up to $500 for each violation. And your decision can be voided by the court. Now, again, I would just point out that this applies to knowingly violation. You don't have to have any intent to violate the law. It just means that you have to engage in the behavior that leads to the violation knowingly. So if you are typing and talking to somebody knowingly, then that could lead to a violation. So there does not have to be specific intent to violate the law, it just has to be a knowing violation. And the cost of any action will be paid by the city or by you if that happens. Are there any questions regarding the Open Meetings Act?
Yeah, this is Jody Meyer. I just had a question. I assume that subcommittees who have less than a majority, are they subject to the Open Meetings Act?
Subcommittees of the body would be open to the Open Meetings Act as well. And then it would apply to however many, say you had 3-person subcommittee, then you'd have the same rules would apply, except for the number would be 2. So those need to be open to the public as well.
Okay, so if there's going to be a meeting, is that something that we would have to give notice about, or only if somebody wants to know when it is?
You should give notice of when the meetings are, yes. And then publish it. What type of subcommittees does the KHRC have other than I know there's the ARC.
This is Jody Meyer. Well, I guess now we have our monument committee.
Okay.
But I was really thinking of like ARC.
Right. Yes, they need to comply with the Open Meetings Act as well. So you need to just give notice of when it is and reasonable access to anybody who wanted to see it, participate. All right, without any more questions, we'll move on to the conflicts of interest. Purpose is basically so that individuals do not use public office for personal gain. This also came about, this was established in the 1970s. It was also part of that same wave of government reform. The conflicts of interest law applies to local officers and officers of subcommittees of the city, subdivisions of the city, so it applies to commissioners on the HRC. Next, Luke. And basically what it states is that a commissioner cannot act on any matter in which it has a substantial interest. He or she has a substantial interest. And there are 5 things listed within the statute that describes what a substantial interest is. So if anything, any person, company, individual appears before the board from which you received more than $5,000 or which you own 5% of, whichever is less, then you have a substantial interest in that person appearing before the board. So if you own 5% of stock in some company and that company appears before the HRC, you would have a substantial interest in that entity. All right, next, Luke. Second one is if you or your spouse has received compensation on your tax return, which would be more than $2,000, then and you would have to report that in your income tax from a business, then you would have a substantial interest in that business or in that person, whoever appears before you. Next, Luke. If during the previous 12 months, you or your spouse has received goods or services in an aggregate value of $500, you would have a substantial interest. So if you win a $500 shopping spree at Hy-Vee, by winning it, you would have a substantial interest if Hy-Vee appears before the board. So just to give you an idea of what that means. All right, next. If you are a director or associate or partner of any business other than certain not-for-profits like the Boys and Girls Club, then you're considered to have a substantial interest in that entity. And next. And then finally, if you receive a commission of more than $2,000 from an entity in the preceding year, then you have a substantial interest. For example, if you are a real estate agent or a real estate broker and you sell property and you get a commission of $2,000 or more, then that company who or the individual who purchased the property through you or used you and from which you received the commission, then you would have an interest in that person or in that business that appears before you. All right, next, Luke. So if you have a substantial interest, you cannot participate. Where would you file? What you need to do is file a statement of substantial interest. The place to file that is with the county election office of Douglas County. That's in the old courthouse. The other thing that you can do to avoid any issues is to just simply abstain. So those are your 2 options if you have a conflict of interest or a substantial interest in anybody appearing before you, is to file a statement of substantial interest with the county election office or just abstain from taking any action either directly or incidental in that matter. And what you'd have to do is typically when we had live meetings, we'd go into the back room and not participate. If you were on Zoom, then you'd have to basically leave the meeting and then rejoin later. All right, next, Luke. Now, the penalties for this, as bad as it is for coma, it's a little worse here because if you actually participate and take action in something of which you have a substantial interest and you did not file a statement of substantial interest, it is a Class B misdemeanor. And the penalties for a Class B misdemeanor are, upon conviction, can be a fine of up to $1,000, could be 6 months in jail, or both a fine and jail time. So these are very serious penalties. A Class B misdemeanor is serious. All right, next, Luke. If you have any questions regarding whether or not you have a substantial interest in anything, there is a governmental ethics commission. You may ask questions of them. They will supply you with a letter in writing. If they give you an opinion and that opinion later turns out to be wrong, you will have immunity. You can rely on what they have given you. Any advice they give you or ruling that they make, you can rely on and you'll be okay. Here's the address for that. Also, if you have any questions, you can contact the city attorney's office. I think I put the number on the handouts and my direct line is there. And we also have questions. Or you can send a question through Lynn and Lynn will forward those questions to me, and we can go from there. So we get probably a dozen from all the various boards that we have around the city, probably about a dozen requests regarding, well, should I abstain or should I not abstain? Those types of deals. So you're always free to ask questions of us whenever you have any. Any questions regarding Open Meetings Act, conflicts of interest, anything else regarding your service on the board?
This is Commissioner Buchanan. I do have one question that does come up often. When clients ask me if I'm interested in helping them with their project, I preemptively say, well, I'm on the Historic Resources Commission. If this is going to be reviewed, I can either abstain from that and take your project, or not work with you and continue my position on the HRC. Is that fair to disclose up front?
Yeah, absolutely. I think it's better to be transparent and to disclose that up front to people coming in. I think that's the perfect way of handling it. Another way of handling it is you could take the business and file your statement of substantial interest that you are doing the work for them, and then potentially you could do the work. And you know, there might be an appearance of impropriety and some people might complain or whatever, but it would not be a violation of law.
Duly noted. Thank you.
All right, this is Chair Meyer. Any other questions?
Lynn Braddock Zollner, Historic Resources Administrator. Randy, can you talk a little bit about when a
Commissioners should recuse themselves.
Basically, commissioners should recuse themselves when only required by law when they have a substantial interest. Now, there may be situations where a commissioner is not comfortable because perhaps it's a relative, or perhaps it's a neighbor, or it's within their own neighborhood, or something of that nature. But those are just basically appearances of impropriety. Those would not necessarily be a violation of law unless they had, under the statute, a substantial interest in those persons appearing or in the particular project. So, you know, when it comes to those types of things, it's up to the individual commissioner's basically conscience. How do they feel? You know, I don't know that I would feel personally comfortable if a family member of mine was appearing before the board and I had to do something. I would probably recuse myself. But that is within your right, and that's just the purpose of being appointed to the board, and you have the right to do it so long as there's no substantial interest involved.
All right, this is Chair Meyer. Are there any other questions for Randy? All right, seeing that we don't have any, thank you so much.
All right, well, thank you, everybody, and we would like to thank you for your service. I know it's can be a work chore sometimes, but it's an invaluable service to the city, and we really appreciate everything that you guys do. So thank you, everybody. Have a good night.
Thank you. All right, this is Chair Meyer again. We will now move on to the second item under our public hearing items, DR 21-55, 7 East 7th Street, which is a sign.
Lynn Braddock Zollner, Historic Resources Administrator. We have one individual that is the applicant.
And for this project, who just stepped out of the room, and Luke is bringing him in now, maybe?
I think they've left.
Is he coming back?
He said he had to do dinner service, so he told me, and I told him he had to tell you.
Lynn Braddock Zollner, Historic Resources Administrator. It appears that he may have left for the evening, so we can move forward with the item. This is a sign for 7 East 7th Street. The property is a non-contributing structure to Lawrence's downtown historic district listed in the National Register of Historic Places, and it is also located in the Downtown Urban Conservation Overlay District.
This is Chair Meyer. Was there any other public comment about this item?
Lim, go ahead.
Luke Mortensen, Planning and Development Services staff. We do not have any Zoom public comment, and we've just been made aware that the applicant who was in person tonight, I believe he had to leave the meeting.
Lynn Braddock Zollner, Historic Resources Administrator. I'll go, if you want to go ahead and hear this, I'll go ahead and give the staff presentation.
This is Chair Meyer. Yeah, go ahead, Lynn.
So the applicant is requesting to install a 4-foot by 5.5-foot wall sign on the east elevation of the structure located at 7 East 7th Street. The structure would be made of plexiglass, and it's important to note that this sign has already been fabricated and was used at the location, the previous location for the business. That location had a significant fire. The applicant chose to move downtown and is requesting to use that sign at this location. The proposed sign location is not typical for the National Register Historic District or the Downtown Conservation Overlay District. Part of the reason the applicant wants to locate the sign here is, as noted in the staff report, the architectural style of this building is not the typical architectural style of buildings downtown. There are some other buildings of this design that do not have signs on the side. This location is also a little unique in that you see the proposed location for the sign a little more clearly than you would in other locations, because the property to the east is set back from the property line, and that gives direct line of sight to this portion or this eastern elevation of the wall. Staff has concerns about the size of the proposed sign. When reviewed for size in comparison to the whole eastern wall of the structure, the sign is in scale with the windows and does not dominate the whole wall. However, the sign is too large when reviewed with the storefront on the north elevation of the structure, and the sign is not pedestrian oriented. Although the sign is large and not typical for the downtown historic district that's listed in the National Register, staff did consult with the State Historic Preservation Office, and they concurred with staff that the installation of this sign does not directly harm, damage, or destroy the National Register Historic District. The sign's also being reviewed, however, for downtown design guidelines. The proposed sign does not meet guidelines 18.2 and 18.8. The size of the sign is problematic. It is not in scale with the primary facade of the structure, nor is it pedestrian oriented. There are design options that would meet the design guidelines. A flag mount sign could provide signage that would be seen from the adjacent sidewalk on East 7th Street and possibly from Massachusetts Street. A smaller sign that is more pedestrian oriented and in scale with the street level facade of the structure is recommended. It should be noticed that there is now a parklet in front of the structure that really has an impact on signage to be able to help people find this business, but that parklet is temporary and the sign placement would be permanent. Overall, staff is recommending approval of the state law review for the proposed project, as it will not damage the National Register Historic District. And staff does not recommend approval for the downtown design guidelines. There are, as noted in your staff report, extenuating circumstances that the commission can discuss, and I would be happy to answer any questions you may have.
This is Chair Meyer. Thank you, Lynn. Since we have no public comment on this item, we'll bring it back to the commission for discussion.
This is Commissioner Buchanan. Lynn, can you verify or clarify the method to attaching the sign? I see the notes all say just gonna use screws. I'm a little worried about the stucco. Other issues, but I do want to understand what the connection methodology is going to be.
Lynn Braddock Zollner, Historic Resources Administrator, that is correct. They are just going to screw the sign into the side of the wall.
This is Commissioner Buchanan again. Is there, has there been talk about using this as more of a blade sign instead of attaching it flat to the wall? Just so it can actually be seen from multiple angles? I know it's too big, but just question.
Lynn Braddock Zollner, Historic Resources Administrator. No, we haven't talked about using it as a blade sign. The construction of the sign would not be supportive of that because it is just the thin plexiglass, and also it would be too large.
This is Commissioner Holder. This was prior to my time on the HRC, but didn't we review a similar sign that was proposed that was not pedestrian oriented across the street about a year ago? Could commissioners who were part of that discussion shed some light on how that was handled? Because that did not meet the downtown design guidelines.
This is Commissioner Buchanan. Am I the only commissioner that was part of that? I know I was on the ARC and we looked at it at the ARC, but is there anybody else? Kent, maybe?
I was there, and I think Kent was also part of the commission.
Yeah, this is Commissioner Fry. I was there talking about the sign, and I think there was some discussion about whether what makes up a pedestrian-oriented sign. I mean, I think some commissioners felt that it was pedestrian-oriented, and some didn't. So there was some concern about what constitutes a pedestrian-oriented sign. And I feel the same way about this one personally. I mean, if you can see it walking down the street, I think it's pedestrian oriented, but that's my take on it.
Commissioner Irby, as I recall with the other sign, there was also some issue with the placement of the sign and how it would destroy the brick of that building.
Thank you. This is Commissioner Holder. That was very helpful. I would tend to agree that for state law review, that the staff findings and recommendations are in keeping with this particular sign. But as far as the downtown design guidelines, Lynn, is the applicant willing to evaluate an alternative to this sign? I know that it's already, they are trying to reuse what they have.
Lynn Braddock Zollner, Historic Resources Administrator. I did talk to him a little bit about a flag mount sign. There was one, I think you can see it on the elevation photograph that was in your staff report. So there has been one flag mount sign there before. It is a new business, and they are trying and struggling right now because of COVID and trying to make a new business work downtown, and they don't have the money to do an alternative sign right now. They're trying to use the sign that they have.
This is Commissioner Meyer. I guess where I'm at is, I guess I empathize with that. However, I mean, the downtown design guidelines were years long in progress, and I don't really want to make exceptions just for that reason. So I personally would agree that to approve the project under state law review, but not under the downtown design guidelines review. But I'm open to further discussion about that.
This is Commissioner Buchanan. Lynn, I know it is absolutely recommended to not paint masonry. Because this masonry is already painted, And this seems to be more in line with what some people call today the ghost signs. You know, more something that's painted onto masonry, which was in the past a common practice. I am questioning if a painted sign would have less damage than using screws to attach this existing one. With the asterisk that I know it's not recommended.
Lynn Braddock Zollner, Historic Resources Administrator. This is actually already painted stucco. So
You could paint the stucco and still meet the downtown design guidelines. I think the question would be the design of the sign and how large it is at that location.
This is Commissioner Buchanan. I think that was my intent, is to say whether or not that's an alternative, and then to look at the scale and proportion. So if commissioners are in agreement that the state law review, it's sufficient, but given the opportunity to do a economically viable, I would assume, alternative that is also more proportionately scaled to the building, should we seek and have a conversation about that?
This is Commissioner Fry. I think that's appropriate to talk with these folks and see if they might want to look at that option. That makes a lot of sense.
This is Chair Meyer. Lynn, I realize the applicant was here and left, but have they expressed any desire to have further discussion, or do you know if they wanted an up or down vote?
Lynn Braddock
Our
Zollner.
Historic Resources Administrator, I think they're just trying to get some signage up to help with their business. So I couldn't tell you whether or not they were looking for an up or down, or whether or not they'd be willing to work.
This is Commissioner Buchanan. Something that stands out to me is the last 3 times I've been downtown, which is rare, but the last 3, this sign seems to have appeared on a podium on the corner. So I know they appear to be, to me, kind of desperate to get the word out, to go that direction and to, hey, there's a new restaurant down here. I don't know what that means. It's something I've noticed, and I thought I'd mention that. I see they are appearing to be struggling very hard to get people down that block.
Lynn Braddock Zollner, Historic Resources Administrator. Using the sign ordinance that we
have for sandwich boards, they have to be directly in front of the business that they are advertising for. So they should be within that storefront area of the business. And it's a little bit more challenging on this particular location because they can't impede the 3.5-foot walkway path on the sidewalk, and that sidewalk is fairly narrow in front of the building.
Commissioner Irby, I'll just say, I was very conflicted about the last sign issue. Because I do think that there are some gray areas where interpretation can come in about what's pedestrian oriented, et cetera. What convinced me the last time was the damage that it would cause to the building. I don't know. I'm conflicted on this one.
This is Commissioner Holder. I think what Commissioner Buchanan Young brought up about the fasteners is important. But more so, I think it would be more important if it was a contributing structure. And what we have here is a non-contributing structure. And while I question if screwing it into the wall is going to have the longevity that they desire, you could potentially inflict damage on the sign rather than keeping it up. Stucco in general is much more reparable than brick and mortar. So from a fastening sense, I think they can achieve what they're trying to. What it kind of boils down to is the size, scale, and appropriateness of that placement on that elevation. I think as it stands right now, it does not meet the downtown design guidelines. I would be in favor of having the applicant discussed with the ARC for to try to come up with alternatives that might meet the cost effectiveness that they're trying to balance. And if they're okay with that, would be potentially delaying until next month before we could review it again.
Lynn Braddock Zollner, Historic Resources Administrator.
So would you be willing for staff to work with the applicant? And if something meets the downtown design guidelines for scale and placement, like a painted sign, that could be approved administratively? Or do you want anything to come back to the commission and go to the ARC?
I'm Commissioner Holder. I would be in favor of staff working with the applicant to try to negotiate something that's more in keeping with the downtown design guidelines.
This is Commissioner Fry. I would agree with that as well.
This is Commissioner Buchanan. During that process, if it appears that they are, for whatever reason, not as amenable, can you then kind of engage the ARC and have an ARC meeting so they can, I'm just trying to understand the applicant's options since they're not here.
Lynn Braddock Zollner, Historic
Resources Administrator. I think that would be up to the commission whether or not they want to firmly send it to the ARC or if they're just going to direct staff to work with the applicant.
Yes, this is Commissioner Buchanan. Candace, trying to help out the applicant since they had to leave and make sure we can complete this in 30 days. Is it better to do a hard pass to ARC because we know the staff is going to work with that applicant but prior to the ARC meeting? Or is it better to just allow staff to work with it? I firmly believe staff could handle this and get them where they need to go. I'm just trying to kind of fail safes to make sure we get this done in 30 days for them.
This is Commissioner Fry. If they can't reach an agreement with Lynn, then they would have to come back to the commission anyway. So they're gonna be compelled to get something put together with Lynn, I think.
Commissioner Hawley, one additional question for staff. I know, just to understand the options, I know that economic costs are not a primary factor in the review process, but they may be considered. Just curious if in recognition to that, there's any precedent for a temporary, like say, allowing the sign to be installed for no greater than 2 years. If the business thrives and it helps, they can afford a new sign. Pandemic's over, parklet issues are changed. That would become an enforcement issue, I realize. I am just curious whether there's a precedent for that. I think the paint is a great idea, just trying to understand the option.
Lynn Braddock Zollner, Historic Resources Administrator.
We do not have any way to approve something with a condition with a time limit on it. That's not something that we have the ability to do right now. One of the things that you may want to discuss is that there is a temporary sign permit application that the sign permit is only good, I believe it's 30 days, and then they can request an additional time period. I'd have to look that up and get that information to you. But whether or not you would be interested in directing the applicant to use this as a temporary sign permit, knowing that it would expire within that time frame, and would the commission even be amenable to having it as a temporary sign?
This is Commissioner Holder. I feel like that's a potential slippery slope. If we allow it to be installed, then we have a basis of extending it. I would prefer directing staff to work with the applicant so that we can reach a resolution that better fits the downtown design guidelines.
This is Chair
Shannon, I completely agree with Commissioner Holder. and that preventing the fasteners from happening in the first place would be preferable. But I appreciate the question.
This is Chair Meyer. I would agree with Commissioner Holder's statements.
Lynn, this is Commissioner Holder. Lynn, if we were to make a motion to, we would first need to make a motion to approve the state law. And then what kind of motion needs to be made to direct staff?
Lynn Braddock Zollner, Historic Resources Administrator, that would be your motion to direct staff to work with the applicant and include in that motion the possibility of a painted sign that's in scale with the size and scale with the building.
Well, this is Chair Meyer. I guess there's, two separate actions that we have to take. One regarding the state law review. So I think what I will do is make a motion that in accordance with the Secretary of the Interior standards, the standards of evaluation, that we approve the project and make the determination that it does not damage or destroy any historic property included in the National Register of Historic Places or the Register of Historic Kansas Places. Is there a second?
This is Commissioner Fry. I'd second that motion.
Okay, since there is a motion and a second, we will go ahead and take a roll call vote on that. Commissioner Buchanan Young,
Aye.
Commissioner Irby,
Aye.
Commissioner Fry,
Aye.
Commissioner Holder,
Aye.
Commissioner Hawley,
Aye.
and Commissioner Meyer is an aye. So that motion passes 6-0. And then I guess I'm trying to figure out how to phrase the motion regarding the downtown design guidelines review. Does anybody have a suggestion?
This is Commissioner Holder. I'll try to take a stab at it. I move that the HRC directs the applicant to work with staff to review the sign permit and to consider options, including a painted sign that is that meets the downtown design guidelines and also fits within the size and scale of the downtown urban conservation overlay district.
Okay, is there a second?
This is Commissioner Fry. I'd second that motion.
All right, seeing there is a motion and a second, we'll go ahead and take a roll call vote. Commissioner Buchanan Young,
Aye.
Commissioner Irby,
Aye.
Commissioner Fry,
Aye.
Commissioner Holder,
Aye.
Commissioner Hawley,
Aye.
and Commissioner Meyer is also an aye. So the motion carries 6-0. Okay. I think then the only other item on the agenda tonight is any miscellaneous items. Lynn, do you have any miscellaneous items?
Lynn Braddock Zollner, Historic Resources Administrator. Yes, I do have one happy miscellaneous item. If you haven't been by already, I would encourage you to go to Grover Barn. The new panel signs, markers are up. They turned out really well, and they're definitely worth the trip up. Of course, always to go to the barn and look at it, but also to read the interpretive signs. When I was out taking photos for a project, there was already someone there reading the sign, so it was good to see that they were already being used. We also worked with our streets department, and they have put up brown signs on Clinton Parkway at Lawrence Avenue that say Grover Barn Historic Site and point the direction south to the barn. So if you have a chance, go check it out. It's nice to see something that you all had a hand in and making sure that it happened, and I think it turned out really well.
All right, this is Chair Meyer. Is there any other miscellaneous comment?
This is Commissioner Buchanan. I want to hand it to staff for starting to include the preservation briefs in the staff reports. I know it's a lot more work, but I really appreciate having those reminders as to exactly what briefs can help inform our decisions outside of just guidelines and standards.
Great, this is Chair Meyer. Are there any other miscellaneous items? Okay, I'm going to take that as a no, and then I will move that we adjourn for the evening. Thanks.